Welcome to the Property Management Law Solutions Podcast. Your host, Attorney Tim Baldwin, will guide you in all things property management, law, markets, politics, and commentary. Your property is his priority. Here's your host, Attorney Tim Baldwin.
Hello, everybody, and welcome to the Property Management Law Solutions Podcast. Thank you for joining us today. We're going to be speaking to our special guests. We have two on the show today. We have Craig Grundy and Hector Rodriguez. Thank you guys for joining us.
Good to be here. Thank you.
Yeah, pleasure.
So for the listeners here, I brought Craig and Hector on because these guys are experts in the area of risk management for companies, and really, as we're going to talk about here specifically, is property management companies, apartment communities, which obviously you guys know who listen. This is what we focus on this podcast, is landlords, property management companies, and that sort of thing. So whenever I came across their information, I thought, well, this would be great for us to talk to them. They are based out of Tampa. Is that right, guys?
Yes.
That's correct.
All right, so they're in Tampa, Florida. You can find them online. We'll get to more of that information in a little bit, but the name of their business is Critical Intervention Services, with over 30 years experience in assisting companies with regard to risk management. And as anybody knows who's a landlord, or at least they should know, guys, is that there's risk involved in the property management business, and there's probably more risk than people would like to admit or to realize. And so I know that Craig and Hector realize that, and they see it all the time, and their job is to help companies avoid those risks as best as possible. And so that's why I want to have these guys on. So Craig and Hector, you can kind of introduce yourselves as you'd like to, and in the order that you'd like to, and just tell the folks a little bit more about yourselves.
I'll let you start, Hector.
Yeah, my name is Hector Rodriguez. I'm the Assistant Vice President of Special Projects with Critical Intervention Services. I've been with the organization for close to 20 years. We are a multifaceted organization that specializes in not only security, but also in protecting and mitigating risk for our clients. These are in areas in multifamily communities to government organizations to private businesses. And so what we do is clients bring us in to be able to, when they have a problem related to risk or related to security measures such as active shooter or theft, or in this situation, premises liability, we kind of evaluate their sites, their organizations, and give them solutions to be able to minimize that risk. So, and Craig here is my boss and one of my mentors, and is a man that I have learned from. And take it away, Craig.
Greetings. My name is Craig Grundy. I'm the Vice President of Special Projects for Critical Intervention Services and a consultant. Specializing in physical security and managing risks of mass homicide. As it relates to this specific discussion today, a large percentage of my work the last couple of years, particularly here in the state of Florida, has been focused on reducing risks of crime associated with multifamily properties. Part of that being organizations that just wish to be diligent and also try to reduce potential premises liability conditions, but also those that wish to benefit from some of the new statutory protections that have been enacted here in Florida.
Right. Wow. Guys, I'm excited about talking to you because I know that, just from my standpoint of representing companies in the property management business, this right here is just a tremendously important topic in many respects. I mean, you mentioned crime, but there's other things as well. Just basic security on the property, reducing other types of risk, even like personal injury and these types of things. But the reality is that these things can be prepared for. And as you said, Craig, there's a statute in Florida that property managers multifamily residential property managers should realize that is there really for their protection. But obviously they have to comply with certain components or all of those components of the statute. So before we sort of get into maybe that statute and those types of things, can you sort of share with the audience what are the most common sort of risks And I know there's a lot of them, but just kind of pick a few that you would like to highlight that maybe a lot of people kind of overlook or don't realize is a major risk in their property management companies.
I'll let you take that one, Hector.
Yeah, I would say that from my experience, sometimes multifamily owners and operators are not aware that they have to have an understanding of what's going around within their community. So sometimes they're so hyper focused on incidents that occur within the community that they don't interact with law enforcement. They don't keep up with local crimes that are occurring. And so they have a duty to care, right? So they have to provide a reasonably safe environment. And so if there are prevalent crime trends in the area, such as sexual batteries or gang activities or shooting or robberies that are occurring, or rash of vehicle burglaries, all of those elements, not within themselves, but added with poor lighting or maybe access control measures that are not working properly, can create a totality of circumstances and foreseeability. And so, from my experience, there's some managers that are not keeping up with what's occurring around as far as crime statistics within their communities and how it affects their residents or could protect their residents.
Man, that's awesome that you're bringing this to the audience's attention. And you hit a point there that's absolutely true, and I see this all the time, is that property managers on a day-to-day basis, they're dealing with what they deal with on a day-to-day. It's collecting rent, it's doing inspection, it's responding to maintenance requests, it's taking applications, placing tenants. I mean, all these things that they deal with on a day-to-day basis that really takes away or can distract them from other aspects of the business that are just as important, which is what we're talking about. So let me ask you this, guys. Do you help apartments and property management companies with sort of how do you deal with this conflict of time management, the day-to-day versus what you're talking about, which is being aware of what's going on around them?
Yeah, I would say that it's important for organizations to have, whether they're using internal employees or they're contracting consulting services like us that specialize in evaluating these types of risks and making sure that they have policies, procedures, and that the physical security is being managed. So, if you have a property manager, their job is to manage the property, but there should be people in the organizations that are conducting audits, are lighting, there's a lot of organizations that have mandatory lighting inspections that have to be done, particularly by maintenance employees. But sometimes people don't manage them, and you might have months of inspections not being done because they're short-staffed or maybe maintenance has been dealing with a lot of after-hours calls, and so those inspections aren't done, and maybe there's a rash of lights that are not working, and somebody falls in one of the stairwells, one of the buildings. Those are some of the risks that if somebody if that's not their main priority in managing, I can guarantee that it's going to be missed eventually.
Yeah, and that's a great point. To kind of add on to what Hector just said a minute ago, a lot of it is about also creating policy that establishes accountability. For instance, to say that we're going to have these lighting inspections conducted on a monthly basis, there needs to be documentation to that effect in order to actually ensure that these inspections are being conducted properly. And also policy that dictates what we're going to do in follow-up to those inspections. So let's say we identified lights out in certain breezeways. Well, a policy might state that that the maintenance has 2 weeks in order to implement any kind of corrective actions with regard to that. Or pruning back, trees that are obstructing lights and things of this nature. When we look, back on various assessments we've done over the years, a lot of it is maintenance related. A lot of the problems that we find, you have existing lighting systems that are out there in place, and they're often just not maintained correctly. You get out there, and then suddenly 50% of the the parking lot light poles and wall packs are burned out. And you've got areas that, when metered with a light meter, are registering at 0.0 foot candles, which is arguably unilluminated. You have, the conditions, the seeds are sown for a liability suit in these cases.
Yeah. So you guys, I know, are familiar with Florida. You guys are in Florida, but I think that you guys do more than just Florida work, right? You guys probably do, everywhere. But you're in Florida, so I'm pretty sure you're familiar with the statute 768.0706, right?
Oh, yes.
Yep. So for the audience, this is a statute. It's entitled Multifamily Residential Property Safety and Security. semicolon, presumption against liability. So this statute provides for certain security aspects of the property that can help protect property managers or the company, the apartment, from liability, but the property managers have to comply with this statute to get some of the benefits of this statute. So first of all, let me ask you this, guys, because I don't know myself, I haven't looked into this, but do you know sort of the history behind this bill, how it got pushed and how it got passed?
Well, as far as the specifics of that section within the statute, no. In fact, I personally have a few questions if I ever met the author of the statute as to how some things got written in there. But the overall law, the bill, HB 837, when it was introduced as a bill, was a tort reform bill largely aimed at kind of taming the litigation landscape in Florida. And this was just one of, several different industries that were affected by, that law overall. This law is really kind of very landmark in that it provides a hugely powerful protection against frivolous lawsuits. Granted the fact that these property owners and management companies implement these specific measures defined in the statute. I'm aware now that there's a couple of other states. I've heard rumblings that they're also considering enacting similar legislation. But to my knowledge, the Florida law is really the first one to kind of advance this far forward.
Yeah, it's not that long, this particular section here, but it requires essentially that the owner or operator of these multifamily properties comply with what's within subsection 2 here, and that includes just briefly stating, security camera system, proper lighting, lighting in walkways, laundry rooms, etc., having deadbolts of a certain size. Locking devices on windows, sliding doors, other doors, lock gates, key fob, and fob access to pool areas, and then peepholes in the door. So that's the 7 that's listed here.
Yeah.
And then it also talks about how there's proper crime deterrence and safety training. So that's part. I want to kind of get into the safety training because there's requirements in this statute that training be conducted by certain qualified individuals who have that expertise. So let's talk about that.
Sure. The way that they wrote that, they didn't actually say it has to be done by certain individuals, but that it needs to be reviewed by, and that it must comply, and that I'm sorry, let me back up for a moment. That the Florida Crime Prevention Training Institute would develop a curriculum, as it were, for this purpose. And so most practitioners that are out there training, for instance, we actually have an online on-demand training platform for this training. Most practitioners, including us, have modeled our training course after the states, just to ensure that it covers all the bases that if it was ever challenged in the future, would be fully compliant with what was created by FCTPI. The way that they wrote the statute is that all employees must complete that training within 60 days of hire. So it's very important, for these organizations that want to be compliant in order to not just ensure that their employees are getting the training, but also to have good documentation in the event that a case arises.
Hit some highlights. What does this training involve?
Well, it covers essentially the way that they wrote it into the statute. It really covers just a review of the issues that are in paragraph A of the statute, which is the 7 physical security related measures that you just got done summarizing. We kind of expand our module a little bit by talking about some specifics of what managers and maintenance personnel can do to ensure that their property remains not just compliant with those 7 items, but also types of crime prevention through environmental design practices, SEPTED practices, that are also going to be part of paragraph B. By the way, the training is paragraph C. Paragraph A is the 7 physical security measures. Paragraph C is a pretty important element too, and that is that a crime prevention through environmental design assessment must be conducted of the property by a qualified practitioner, either a law enforcement officer or a Florida or designated Florida crime prevention through environmental design practitioner. And then they must be substantially compliant with the assessment. Now, working with a lot of these companies over the last year or so in achieving compliance, there's often this great energy in the beginning. We get the assessments done, we get the reports, and now we're going to go ahead and get the lighting improvements made, maybe landscaping changes and other things like this done. And now it's got to be maintained. And that's where quite often the shoe begins to fall over time. And, we don't want to put a whole lot of money in all this and then suddenly see our status as quote unquote substantially compliant begin to deteriorate over time, as a result of poor management. So we added an extra module in our course, kind of addressing this matter, things that they should be doing.
Yeah. So, sometimes, what I have seen personally in my career is, and maybe it's one of the more common ones I see is where you have a tenant living in an apartment and this tenant has a boyfriend, let's say, and the boyfriend's not living there, but he frequents the property. So the management may know that this person, has a boyfriend that comes and goes sort of. And then this tenant and the boyfriend end up having a domestic violence dispute or serious physical harm. So, how does sort of this safety and the protocols that would be in place for situations where you're not dealing with someone who's intruding necessarily, but they've been there, they frequent the apartment, so they have access. But they ultimately, that person ends up causing, creating a crime situation for that tenant.
Yeah, I would say, I mean, there's multiple factors when it comes to situations like that. We do a lot of expert witness testimony as well. If the individual's an invitee, management is unaware that there's a unauthorized, resident living in that apartment, I think the risk is somewhat minimal. You have to be able to prove foreseeability, and that management or ownership should have took some type of reasonable steps to prevent that. But what I would say is that where we see the biggest risk is when, again, as we talked earlier, lights are not being maintained, trash is not being picked up, a failure to notify. We've had situations where there's been a rash of burglaries, or maybe there was a robbery at the mail center and management did not notify the community of a significant crime that occurred within the community or near the community. And so if, my wife goes and checks the mail and she becomes a victim as well, I think there's an argument to be made on the failure to notify that my wife could have said, I'm not going to go out there at 10 o'clock at night because management told me about that robbery. I'll go check it in the morning. Or I'll wait my husband to go check the mail. Those are events or situations that can significantly expose clients to liability. Now, this statute provides them an assumption against liability if they are substantially compliant. I think the important part of the statute is substantial. It's not saying you have to be 100% compliant, meaning that if you had one wall pack out or maybe you had 3 street lights out, that doesn't mean that you're not going to be protected. It has to be, as long as you're substantially compliant. But as Craig's point earlier, we see a lot of clients that are going into this, and we also see that potential insurance premium reductions, where we have a lot of insurance companies now that are requesting or might be requiring their clients to be able to do this because there's such a powerful protection against it.
Yeah. Now, not to get into expert witness testimony here, but one of the things, unfortunately, that's happening now, and we see it more frequently, is shootings within apartments.
Yeah.
And so when that happens, clearly the managers are nervous about the safety of the entire community, and at times it's difficult to prove identity of who this person may be. And many times it's also an occupant who may not be named in the lease, but they're maybe a guest or an invitee in the property. And then also they have to work with police. Well, I can tell you from experience, sometimes it's hard to get information from police because there's an active investigation going. They don't necessarily disclose information. So that leaves the managers somewhat with a lack of knowledge or a lack of information to be able to take steps of terminating tenancies properly. How do you advise clients, like when you face that situation, how do you protect yourself as a company if you don't necessarily have the best information from police investigation?
Yeah, so that's actually a great question. And so what I have found is that you'll have multifamily communities that will have security or courtesy officers or courtesy patrol. And when we conduct our assessments, we see all these emails or reports that are being submitted and there's nobody reading them. So if you are having a third party service that you're contracting for this particular reason, there's a couple of things you want to do. You want to make sure that the scope of work is very specific in those service agreements, that they're out there to report lights that are out, that they will address community violations, that they will document community violations, because that will empower management to be able to utilize those reports as third-party documentation to send a 7-day notice to cure, to send a 7-day notice to vacate. And so that could be a very powerful tool. But quite honestly, a lot of times I see multifamily management companies or operators that are hiring security or courtesy officers, and they're just there as a visual deterrence and not given a real mission that is binded by a contract with a clear scope to make sure that they're using that manpower effectively. And so a lot of times you can have security or courtesy officers out there reporting residents that are outside, with open alcohol containers or failure to maintain control of guests. And so that's a powerful tool, because a lot of the frustration comes with a manager going, I don't know what to do, Hector. I have these residents saying that their neighbors are doing this and they're doing that. And there's not a judge in the state of Florida that's going to uphold an eviction because the neighbors are saying they're doing this.
Yeah.
So what do I do? Well,
Yeah.
you have a security company out there. So make sure that they're focusing on that, providing you documentation. You can use that third-party documentation to get those nuisance units out of the community.
Now, in general, would you say those security officers are these like former law enforcement officers in general? Is that typically what you experience?
Sometimes, often not though.
Okay, but they're trained in security.
Yeah.
Okay, so in those situations, like, so you're talking about your contract with these individuals or with these companies. Would you say that those agreements should include the duty of those officers or the security officers to actually go and do some investigation? So talk to witnesses, talk to neighbors, take reports, take videos, take photographs, that type of thing.
Yeah, absolutely. I mean, they're there for a reason. And there is a difference though when you are deploying armed versus unarmed officers. You're not going to have employers sending their unarmed officers in environments where they could potentially get themselves hurt. But, as far as a post-incident investigation, law enforcement's arrived, they've conducted their investigation. There's no reason why they can't be interviewing residents or guests nearby, taking pictures, documenting what they know, and making sure that they communicate with management on that. And so, it really is important to make sure that everybody is clear on their roles and responsibilities.
Craig, you want to add to that? I think, I think I was going to make a comment myself, but I didn't want to cut you off if you had a comment.
No, please go ahead.
So you mentioned the policies and procedures, and I preach this all the time, is that you have to have good policies and procedures for every aspect of this business, because the liabilities are just too great, and this is one of those areas that you have to have. So let's sort of try to inform or enlighten the listeners a bit to say, what have you seen in your experience, sort of like bad case scenarios where, because they didn't have the proper policies and procedures, it ended up resulting in liability for apartments?
Yeah, absolutely. I could take that. So they have policies and procedures on lighting audits that were not being conducted. They were not being documented in the period of time that was established by protocol. And so I've run into two separate scenarios here that these policies and procedures either didn't exist or they did exist. And when they did exist, sometimes we'll have clients that say, well, let's just get rid of the policy. And so if we forget about doing it, in 2 months, it won't hurt us. And I said that it doesn't work that way.
No.
So we have to have strong policies and procedures and making sure that's done. The other thing is that they have contracted security companies, and it's a partnership, right? They shouldn't be contracting security companies and being used as an additional, form of insurance. That's not right. So there has to be clear indemnification language in there to protect the management company and fair language to protect the security company, but there has to be a clear scope of work. So security companies typically have what's called post orders. And so post orders are documents that are specifically generated per property, per project. So they could sit down with the manager and they could say, okay, what are we going to do? We're going to lock up the pool at 10 p.m. We're going to document lights that are out. We're going to document residents or guests that are not, adhering to community rules. We will respond to calls for service, which is a big one, right? So we want to be able to retain our residents. That's a big part of multifamily. We don't want turnover. We don't want to be able to spend that money. Well, if you have a third party, security company that's patrolling, make sure that your residents have that number, because a lot of times they're reporting quality of life issues, noise issues, juveniles running around, maybe there's a party. And right now, law enforcement, it's going to take them forever to respond to situations like that. And so if they have that third party to be able to call and say, hey, I got a noisy neighbor, I don't want to let you know who I am. Security can respond, document it, and provide, management with that documentation to follow up on that.
What about pets? So I get this one a lot, where there's a pet on the property, or maybe it's even a service animal, and that animal becomes aggressive towards residents or even other animals. I mean, do you see security as playing a role in that scenario too?
Absolutely. Yeah. No, I have seen post orders where if a security officer observes an aggressive breed and management provides them, what acceptable breeds they are, they could document it. As simply as, I saw a resident from apartment 314, walking a pit bull or a German Shepherd, in front of, the dog park at 4 p.m. on such and such date.
Yeah.
That provides management with enough information to be able to send them a notice to cure.
Yeah. And another one I'd say probably even more common in many cases is, animals that are off leash on property as well, too. That's a big problem.
Right. Well, and unfortunately, it's one of these situations. Is it inevitable? I guess you could say it is. I've just seen so many examples of situations where animals are off the leash, even when they are within a designated pet area, like within a fenced area. A child goes into the area with their little chihuahua or their little dog, while there's another tenant in there with an aggressive dog, and the result of it is just disastrous. And even in that situation, maybe you can speak to this, but the tenants are going in there thinking that they're in a safe place. This is the designated area for pets, but lo and behold, there's an aggressive dog, and when children especially are involved, very, very potentially serious situation. So let's speak to that a little bit. I mean, maybe the listeners can glean a little information here.
Yeah, well, I always start with the lease agreement, right? So if you're providing these amenities, we can't say that, you're going to be 100% safe all the time. That's unreasonable. So making sure that you have language in there, letting them know that at the dog park, they are taking their own risk by bringing their dog there, knowing that there might be potentially other dogs that might be off leash, if that's, part of the rules of the dog park. So we want to be able to transfer as much risk as possible. But the other thing where I see more often is the bigger risk is the infrastructure of those dog parks, meaning that the locking mechanisms are loose. It's usually a latch, and the latch is not tightened up, or no one's inspecting it, and the dog's able to push the gate open, or doesn't lock properly and gets out and bites somebody. Well, in that situation, even though you have language in your lease agreement stating that utilizing these areas, you are taking that own risk. But if I'm a resident, I reasonably believe that when I lock that gate behind me, it's locked. And if it doesn't, I'm not going to take on that liability, and that might be potentially the operator or the owner of the community.
Yeah. Well, even with regard to minors, is having rules about not letting minors inside of a gated, fenced area like that without the parent, especially if they're under a certain age of accountability, if you will. So
that's a great point. If I can actually add to that, a lot of times we look at amenities and they are not posted rules. Craig and I find that all the time, where there's not hours of operations, or they're not specific to ages of who can utilize those amenities, or if there's a specific age that needs to be supervised by an adult. And that's important, right? Because let's just say from the vantage point or from the aspect of crime, if you have gazebo or outside sitting areas that do not have hours of operation, well, then potentially you can have people loitering in those areas at 12, 1, 2 o'clock in the morning, which nothing ever good happens at 1, 2, and 3 o'clock in the morning, right?
Yeah.
So, making sure that we have those hours of operations to make to say that those people shouldn't have been there. It's in our lease agreement. We tell people it's actually posted there, the hours of operation, and therefore, there's a certain level of protection when it comes to that.
Yeah, and if I may just kind of add a related point, to several things that we've discussed so far, whether we're talking about the maintenance issues, whether we're talking about different kinds of, people, violating community rules and things like this. Another deadly sin, as it were, property management is ignoring resident complaints. You get residents that complain about these various different issues, especially when those complaints are coming in a written form or being documented in some particular manner. That is all generating foreseeability. So if they are not acting on that stuff after they receive these kinds of complaints, that foreseeability just continues accumulating, and it's setting them up for disaster in the courtroom.
No, that's an excellent point, and you're right. The legal standard of foreseeability is crucial. And so, going back to sort of the management being strapped with all these daily tasks, it's like, no, you've got to take the time, review these complaints, do due diligence, and address the concerns. Because you're right.
I'll give you, just a real quick example. I did an assessment, some time ago where there was a building, because of an electrical problem in the building, all the breezeway lights were out. So in other words, the breezeway was pitch black, so dark that to safely navigate the stairs in the hallway, you had to use a flashlight on a phone. And one of my questions at the time was if there have been complaints from residents in the building about this condition. First of all, nobody really gave me a clear answer as to how long it had been like that. I didn't know if it was a day or if it was weeks. And, in this case, it wasn't even just a security issue. This was a pure safety issue at this point. And what it turns out, that there had been some complaints that had been made about the matter to me. And my advice to them the next morning was to get an electrician out there and get this thing fixed. I could not sleep myself at night thinking about the possibility that somebody took a tumble down those stairs. They would have gotten strangled in the courtroom.
Yeah. So let's talk about sort of the cost prohibitiveness. So I know that you probably come across potential clients who are interested in services like this, and they say, well, I just don't know if we can afford it. And the response may be something along the lines of, well, really, you can't afford not to use this service because the liabilities, are just too great. So how do you sort of talk to people about, the cost involved and how to make a good decision in this regard?
Yeah, well, let me kind of approach that on two ends. We got this new law here in the state of Florida, which provides this, this pretty powerful liability protection as a strong incentivization for properties in order to bring themselves up to a pretty high level, as it relates to crime prevention. In their particular case, there's a whole bunch of benefits. I was talking with somebody about this recently the other day. I was describing, we have several different kinds of clients. One major category of client that we have, and a category that really jumped on that law early, are those that have been to the rodeo of big litigation previously. Those that have had multi-million-dollar judgments awarded against them in previous court cases, and they realize, an ounce of prevention is worth a pound of cure. And they completely saw the wisdom of this and were more than happy to spend whatever it took, within reason, of course, in order to bring their properties up to a compliance standard, we'll say. Now, in other areas of the country, it's mostly just going to be about trying to stay ahead of whatever those liability conditions are that would otherwise lend themselves to the success of a plaintiff's lawsuit. So, to what, degree the cost benefit, analysis shakes out kind of depends on the situation in many cases. We do a lot of, if you were to look at our reports, probably the most common big ticket items that we, recommend improvements in is lighting, for one. We find a lot of deficient lighting out there. Florida actually has requirements for that. Other states don't, but IES, the Illuminating Engineering Society, establishes best practice guidelines for illumination. I recommend for best protection from a liability perspective to at least comply with the IES guidelines. This way, if you're asked whether or not you meet certain standards, if they're not defined by statute in some manner or regulation, then at least you have the IES as a backup. The other big ticket items are sometimes cameras in some cases. And, we also, in crime prevention through environmental design, there's this concept of natural surveillance, meaning that you can see around you clearly as you're navigating through an environment. And there's certain kind of guidelines that are used for SEPTED design that would relate to multifamily properties. And where they mostly come into play is when we talk about shrubbery and trees and things like that being obstructive. So sometimes, some properties, there may be upgrade or expenses associated with improved landscaping, trimming or removing shrubbery that is obstructive, that provides a lot of concealment opportunity, for potential offenders, or obstruct sight lines as people navigate the property. But those tend to be, the areas where the expense usually shows up.
Well, here's what
Yeah,
yep, go ahead, Go ahead, Hector.
I was going to say, in our experience, two things. One is some of the new developments actually mostly comply with these protections. And so, part of our work too is also doing plan design reviews for architects to make sure that they're going to be in compliance. But the other aspect is that when you are going to do these upgrades is making sure that we are transferring risks. So a lot of times we will have our clients send out an addendum to let's say their landscaping company, where shrubbery under SEPTED standards should be a minimum of 24 inches. Tree canopy should not be lower than 6 feet. And so making sure that there's a scope of work that they are responsible to make sure that the landscaping complies with whatever upgrades or whatever changes were made, and so that we could transfer that risk. The other thing would be is hiring a surveillance or a CCTV company that will come out and have a maintenance plans for your cameras. So scope of work would be, like the statute says, all points of entry and exit must have a surveillance camera that can assist with identifying an offender. And that footage needs to be able to be retained for 30 days. So having a maintenance plan with a company that will make sure that the cameras are operating properly, and also certifying that they have 30 days worth of retention. So if something should happen, there's some indemnification that the client can go after, to be able to protect them.
Yeah. And in the case of the Florida law, demonstrate best intent in order to be substantially compliant with the law.
Well, I know that the prevention of risk and liability is worth it. So when I have clients, many of them who pay me just to be there for advice, to help them draft, their leases, their addenda, their policies, procedures. And because they, like you said, Craig, earlier, they have learned through experience, or they can just foresee that if they don't have that professional input and advice, they're leaving themselves open. And it's the same thing with you guys. You're filling a need. You're filling, and just for the audience, these guys are not paying me to say this, but I can just tell that based on what they're doing, this is the type of service that apartments should pay attention to and take steps to implement, because you do not want to leave yourself open. And chances are your employees and your managers don't either, one, have the expertise, or two, the time, or maybe both, to deal with these types of issues on a regular basis. So I really appreciate what you guys are doing. We're kind of already past the 30-minute mark, guys. I told you I was going to keep it at 30 minutes, but man, this has been very interesting. We could talk all day about this. But could you just leave the listeners with sort of, if you're going to leave them with a gold nugget, like, hey, if you're going to remember anything, remember this. Let's talk about that.
Go ahead, Hector.
I would say is, as an owner or operator of multifamily, you have a duty of responsibility to provide a reasonably safe environment for your residents. And so I think that it's important for you to be able to outline areas of safety and concern that you should be able to manage on a day-to-day basis, whether it's lighting, whether it's surveillance camera, whether it's access control, whether it's meeting with law enforcement or your security provider on understanding crime. Prevention is extremely, extremely important. And so don't get hyper focused on the day to day, what's my occupancy percentage, what's my retention percentage, am I meeting my budgets? All of those things are very important as a business organization, but these are life safety. And I can tell you that, where owners and operators get affected, it's not by the damages, it's by the punitive damages. It's by when a jury says you should have done this, you know better. And not only do you have to pay the $300,000 with the medical bills, but they hit you with the $1 million of punitive damages because you should have foreseen this coming. And so this is extremely important, not only from a financial aspect, but from a life safety aspect and from a branding aspect, right? Because any type of critical incident that happens such as this, not just affects the communities, but also affects the organizations and their brands.
Yeah, I think, I think Hector made some excellent observations, just to kind of elaborate on that. Historically, so many in the multifamily, property industry, when they think of risk management, think about insurance. That's it. It's pretty much, defined by consequence mitigation as opposed to prevention. And truthfully, this is one area where the investment in both effort as well as also in some cases, maintenance costs and capital investment to make certain kinds of improvements pays for itself well in the long run. Both by reducing the potential for crimes and reducing safety conditions, but also if and when a court case does arise, the better prepared we are in order to demonstrate that we used reasonable measures, complied with best practices, and that the stronger we bolster our defense. And it is less likely that a plaintiff attorney is going to try to fight an uphill battle in those cases.
Yeah. Wow. You guys both said a mouthful. That's great information. If you're listening, you really need to take to heart what these guys are saying. I know their perspective of doing what they do, is extremely valuable. But I can tell you just from my perspective that what they're saying is valuable, and you should listen to it. So do you guys give presentations throughout the year for like seminars and these types of things for people to learn about more?
Sure, we do occasionally. I just gave one recently for for IREM, here in Tampa Bay. And so we do. We post it occasionally on our website.
Okay.
Yeah, and if you go to our YouTube channel as well, we have a lot of videos, and then CISworldservices.org, you'll find a lot of informational training that we do on there as well.
Well, I'm down in the Tampa area quite frequently because I speak at events down there, and I'm glad to know you guys. So next time I'm down there, maybe we get a bite to eat or just catch up. I've enjoyed getting to know you. And so, as you said, Hector, your website is CISworldservices.org. Is that correct?
That is correct.
Okay, I'm going to post your information on the notes so people can get in touch with you if they'd like to, and I'm sure they will. So, guys, hey, listen, I appreciate your being on the show today. It was great information. I had a great time with you guys. Hopefully, we'll do another one in the future and delve into some more of these issues.
Sounds great. Thanks for having us.
Thanks, Ray.
All right, guys, this is going to do it for the show today. Thank you for joining us, and we'll see you on the next episode. Bye-bye.